Well, hello and welcome back to my channel. Yes, I know that it's like a really weird hour for a lot of people overseas. It's a weird hour here in Australia. It's like middle of the afternoon. But it's just popping off everywhere. We have to talk about this. This is much more exciting than my assignments. So, you're dealing with a lawyer. I'm a law student from Australia. Defamation is different in Australia to the US. So, but it's, it still gets very interesting. Now, what's very interesting, so there was a statement by Without a Crystal Ball or Katie Joy that said, an update on Todd Chrisley's ongoing defamation of Without a Crystal Ball and Katie Paulson from our legal team. That was edited because that didn't say that before. In light of Todd Chrisley's choice over the past year to repeatedly misstate the facts and tell lies about the activities of Catherine Paulson and Without a Crystal Ball, and in light of his ongoing and very public defamation of Miss Paulson and WACB during the pendency of his lawsuit against him, what on earth is this garbage? Miss Paulson and WACB have decided to withdraw the motion to dismiss of his complaint and instead file counterclaim in the case, which will be served and filed in line with a timetable dictated by the court. Miss Paulson and WACB have reserved their right to refile their motion to dismiss at a later date, if appropriate, and considering any additional information that may be disclosed during Mr. Chrisley's upcoming criminal trial. Without a Crystal Ball, we'll continue to report on the Chrisley's upcoming criminal case, but we'll have no further comment on the civil case. Now, I've got a problem with this, actually. I actually have a few problems with this. Now, she says, considering any additional information that may be disclosed during Mr. Chrisley's upcoming criminal trial, right? But then she's saying that she's going to talk about the criminal case, but not the civil case. Well, if you're wanting to get information from the criminal case, Katie Joy, you can't be talking about it. Hello, The Fox. Hello, Nail. Hello, Angela. Hello, Plan to Create. So, yes. So, by her own words, there's no... I've just checked again. And there is no... this is... Oh, that's the 7M. I'm still looking to see whether anything filed. There's no documentation filed. There's no more documentation that's been filed in the Chrisley case, so that hasn't hit the court filing yet. This has me... I mean, if I could like this 100 more times, says Toad, I got you, fam. What on earth does that mean? And then he says, now... I don't know. I don't know what she's talking about. Choice over the past year to repeatedly misstate the facts and tell lies about the activities of Katie Paulson and Without a Crystal Ball. In my opinion, hasn't she been misstating facts about him? Just because somebody says stuff about you doesn't mean that it's defamatory. Someone cannot like you and say some mean stuff, but that doesn't mean that it's defamatory. So if we go over to Todd Chrisley's here, he's written here, let the games begin. Already running out of money. So soon with so many more suits to defend. This is going to prevent her from buying not one, but 2 Bentleys. Then he says, LMAO. I see you peeking. Then he says, don't make me post that email begging for no further litigation because you are out of cash and don't want no more litigation. Yep, I got it, trick. So from what Todd Chrisley's saying is that she doesn't want, she's got no money, allegedly. So... don't make me show that email. And yet she's saying she's countersuing him. You know what? She actually would be better of putting in a very solid defense, actually. But there is no... I mean, I don't think she's got a defense. I can't come up with a defense. But that's just my opinion. So then we've got this. Look at this from Lindsay Chrisley. So it says, "Good evening, friends. I contemplated even sharing, but the amount of attention this is getting, I need to address and exit the room. On Friday, I was accused of threatening to sue a YouTuber on Coffee Convos podcast for defamation. Anyone who knows me personally knows I don't threaten anything. If I want to do something and am within my legal rights to do so, I will. This allegation is widely false. I have simply asked for my name, image, and likeness not to be used when reporting. It was alleged that her counsel had a teleconference with the US Attorney's Office, who allegedly claimed I am a witness in a federal case. Said YouTuber claims that I have even changed testimony, etc., without even speaking to me. This is dangerous and reckless behaviour. This is a federal case awaiting trial. It's alarming that any prosecutor or federal agent would just freely give up information on an alleged witness to a non-party. That is actually very concerning, if true, and also could actually be deemed a contempt of court and actually have everything dismissed. Wouldn't that be funny if by Katie opening up her big mouth, she got the Chrisley's case dismissed? Just saying. Just saying. Because that is a breach. And I would imagine that if this paragraph is true, and we know that the YouTuber she referred to has stated that her lawyer had spoken to the US Attorney's Office and said that Lindsay was a witness. That could have very serious ramifications on the matter. I mean, it could be a mistrial. But anyway, so as I've stated several times before, this is damaging to my mental and emotional health and brand at this point. Her husband has joined in to harass, speak about me, and slander me. It's so sad that people thrive and financially benefit and prey on people when they are aware of the mental impact they are having on another human being. Maybe spend less time focusing on another human's downfall and more focused on things focused on things that positively impact your life. Stop reporting on any Chrisley. Simple. Stop reporting and attaching my name and image. My attorney will be in touch this week. Now she's saying here, stop reporting on any Chrisley. So no reporting on her parents, no reporting. I would imagine that when she says that her lawyer would be in touch, I can only assume that that's going to be a cease and desist. Hello, without a lawyer. So Todd Chrisley, as we said, is just living for this at the moment. He has just said, bring it on. Now, I don't know. I mean, she's not filed a defense to any of the allegations from Todd Chrisley. She filed the motion to dismiss and said the allegations were baseless. Here's my thing. I don't understand why you would get rid of the motion to dismiss and not file a counterclaim. Because you can still do both of those things. In fact, you can have a motion to dismiss and then go in and sue. Because remember, if you get them into the court's going to deal with them. I know I've seen it done in Australia. Unless, of course, she was told that the motion to dismiss was unlikely to succeed, and then she's gone. And don't forget, she still has to meet the discovery requirements as well. And so she's trying to fight discovery requirements. And in my opinion, what an awful waste of money. What an awful waste of money, because she's had her lawyers file all this correspondence and then she's just going to dump it. Really weird. So it's so on the 25th of so it's definitely going to be very interesting to see, because she's dropped the motion to dismiss. The court has not been updated to show that tomorrow's hearing is not happening. It's still showing that it's here. There's nothing been updated on here. So what's everyone's thoughts on this matter? Because this is wild. Reset by court to 27th of the 4th, 2022, 2 p.m. The original hearing date was the 26th of the 4th, 2022. And it was reset to the 27th of the 4th. There you go. She's filed something there. She's filed something. So we've got all of this stuff here from Chrisley. So it's cost her $370 to file whatever she's filing. So that must be the counterclaim there. Or was that the motion to dismiss? She has to file. See, there's the motion to dismiss, but we've got nothing. There's been nothing in here, because she'd have to file a in Australia you'd have to file a discontinuance. So, and we're still waiting for the 7M stuff, and there's nothing there either. So, yeah. So I'm interested to know what everyone's thoughts are on this. This is just wild. This has nearly got as many twists and turns as the Barilaro and Shanks defamation case. You know, it's crazy. And now Lindsay's saying it. What are we thinking? And I also think Todd's calling her bluff. We know that a lot of this stuff, I reckon, is played into his hands. He knew that if he antagonized her enough, she would bite. Again, it reminds me a bit of the Shanks Barilaro stuff, because look at how Shanks dealt with the how he just antagonized Barilaro. So there's some similarities for that, except and I would assume that Chrisley knows what he's doing. His lawyers would have, because if you actually, everything's been calculated. It's part of the strategy. And so he's just enjoying this, as far as I'm concerned. So, thoughts? Anyone got any thoughts? Oh, by the way, I found my purse too. Do you believe it? Somebody found my purse in the supermarket and had handed it in, and I just went, I don't think it's here. And they said, yeah, it is. They said, we know who you are. We saw your photo ID in your purse. So they recognised me and they went and got it. And they said how extremely lucky I was. So I'm very grateful that it was found. So yeah, so that's where we are with the latest Chrisley stuff. But as I said, we've got no filings. I am assuming that it's going to happen later, probably later. I won't be on. I've got surgery tomorrow, so I won't be on and for a few days. So it's funny, they've already made my ad. They've already flagged my video. They've already flagged my live stream. Buying time is my guess. Look, she probably is buying time. I mean, which I think is very foolish. You know, again, it's quite foolish because she's just delaying the inevitable and racking up costs. Look, I don't know what. Well, the thing about what he's filed is that he can add more to it. The thing is, whether I think he's got a case or not really doesn't matter, but because the way that she's reacting at the moment, I mean, she's just going to get laughed out the park. Because she will actually have to play, they will have to play Chrisley Knows Best. And she will have to tell the court she's going to have to say, when he said this was defamatory. And the court's going to look at her and say, no, he was just making a comment about parenting in general. That wasn't about you. You know, if I've listened to the Chrisley podcast. Did what Chrisley say was, I'd say it was, did he have go with her? Yeah, but I don't believe that he was defamatory. Yes, I did hear that Emily D. Baker passed her in subscribers. That's gonna hurt her as well. Definitely gonna hurt her. As I said, she's got the 7, and she's got the 7M, and she's got the 7M. She's got Chrisley, and there's supposed to be some more, and she's likely to be getting. I mean, I can only ascertain by Lindsay saying that her lawyers will be in touch this week that she'll get another cease and desist. So, but I don't know how she can say on her post that she's going to cover the criminal trial when she's hoping that something from the criminal trials is going to help her civil case. Those two don't work. You can't talk about... Judges don't like to have to intervene to order discovery. No, they don't. And... that is correct. They don't like it. So that's the issue that I've got at the moment, is that she's talking about... I'll just highlight it again here. I mean, if her lawyers wrote... I don't believe for 1 minute that her lawyers wrote this, because there's no way that they would say this, considering any additional information that may be disclosed during Mr. Chrisley's upcoming trial, right? So she's hoping, she's hoping she's got what she wanted, that she can deal with this case after his trial in case the trial comes up with something she can use in her civil case. But then she says, without a crystal ball, we'll continue to report on the Chrisley's upcoming criminal case, but we'll have no further comment on their civil lawsuit at this time, right? That is my issue. If she's expecting to get information from the criminal case, she can't be talking about it. Because you can't talk it, because if you're looking to get information from the criminal case, she's in your civil case. You can't be talking about it. Just my opinion. So, I mean, I would like to think that they would. I would like to think that they would have a go at her for wasting court's time. because she could have easily. Why did she wait till the day before? No, our defamation law is different, Cal. And I'm not sure how different, but it is slightly different. Yeah, I think in defamation law, the onus is on the defendant to prove that it wasn't defamatory. From what I can work out, but don't quote me on that. I'm just a learner. That's my excuse for everything. So the other thing that's really interesting, remember she's been going after 7M. Well, now she's gone in and she's starting to dig deep into Todd Chrisley. He's got a production company called 7Cs. 7Cs, 7M. Hello? Seven C's, 7M. What is it with her and sevens? So let's have a look at defamation. I'll have a look in here, see what we've got. See, I know. The other thing is she hasn't bothered to file a defence to it either. So Katie Joy has not said, hey, I'm going to file a defence to defamation. Okay, so defamation in Australia, it does not require proof that the defendant was at fault, meaning that it is irrelevant whether the defendant intended to cause harm to the plaintiff's reputation. It is also irrelevant whether the defendant acted with reasonable care in publishing defamatory matter. Further, the plaintiff does not bear the onus of proof to establish that the defamatory matter is false. The defendant's ability to establish the truth of the matter in the defence is critical. So, if Chrisley and Paulson were in Australia, right, Paulson would have to prove, that what she said wasn't defamatory. So, yeah. They've had, so that's why in the Barrett Google and Shanks had said we were, partial truth, whatever. And then every statement is an imputation. So it's called imputations. So defamatory imputations are critical to defamation. The plaintiff must demonstrate that a matter contains a defamatory imputation that conveys a certain meaning and lowers the plaintiff's reputation in the eye of the ordinary reasonable reader or hypothetical referee. An imputation is akin to a suggestion, as it requires one to look at the meaning behind the word, phrase, or image to identify a message suggested to a third party. So take an example of a statement made about a prominent athlete. It's not possible X has tested negative to illicit substances. He won 11 out of 12 matches following a year-long break to injury. That is impossible. It tells you everything. That statement could be interpreted by a reasonable person as suggesting that X uses performance-enhancing substances to win matches. When a defamation claim is being heard before a judge and jury, the judge decides imputations that can be reasonably be drawn from the matter and put to the jury. The jury must then determine whether the imputations are defamatory. For example, in Boyd versus Mirror Newspapers Limited, the court was required to determine whether words in the newspaper headline could give rise to 3 imputations. If the imputations were capable of being defamatory, they'd be sent to the jury to determine whether they were, in fact, defamatory. So defamatory imputation may be conveyed through a natural and ordinary meaning of the words Y is a thief or Z is a murderer. In instances where natural ordinary meaning of words is used, the imputation is clear from the literal interpretation of the words. Hence, it is unnecessary to read into the words used. In contrast, defamatory imputations may also be communicated indirectly through innuendo. Innuendo looks at the insinuation that can be drawn or interpreted by a third party, where direct words are not used to convey the message. The difference between a true and a false innuendo is significant. Is that helpful to you? So it's about reputation. So if a statement is made, so the first type of imputation is the false, and is based on the meaning that an ordinary person would understand from their general understanding of a popular culture, the contemporary meaning of a word in phrases. For example, the comment by D that P had their hands in the till could be understood to infer that P dishonestly misappropriated funds. The second type of innuendo is known as a true or legal innuendo, which is conveyed to a limited group of people who assign a particular meaning to the words due to intrinsic knowledge. Essentially, these individuals are privy to knowledge or an understanding of facts not contained in the defamatory matter. For example, in Briscani versus Pisoneri, the term ex-lawyer could be interpreted by individuals with knowledge of the requirement to be admitted to the legal practice to infer that the plaintiff had been struck off the Supreme Court roll. Without this extrinsic knowledge, one might simply believe the plaintiff had elected to change careers. Where there are multiple meanings that can be attributed to an imputation, one defamatory and one innocent, the courts have applied the single meaning rule. In Corns versus the 10 Group Proprietary Limited, prominent comedian Mick Malloy stated, "And apparently you slept with her too," on a football panel show. While some of the audience viewers may have been familiar with the comedic nature of the show also purported to provide factual information. The Court of Appeal concluded that Malloy's statement could be interpreted as defamatory by an ordinary, reasonable viewer of the program. Once a court has deemed a matter capable of being defamatory, the plaintiff is entitled to plead multiple defamatory imputations as arising from the matter. Once the plaintiff has established the existence of matter containing imputations, the plaintiff is also required to demonstrate the imputations are defamatory and carry a sting that lowers the plaintiff's reputation. In Radio 2 UE Sydney Proprietary Limited versus Chesterton, the High Court of Australia confirmed that the test for assessing whether statements are defamatory include determining whether statements lower the plaintiff's reputation in the estimation of others, expose the plaintiff to ridicule or contempt, or induce society to shun or exclude the plaintiff. The court also endorsed the principle that imputations will be defamatory if understood by an ordinary, reasonable person who of ordinary intelligence, experience, and education, and not avid for scandal. Recently, in Trakjija versus Google, the High Court considered whether a Google search of the plaintiff's name had elicited search results of a criminal underworld figures could be defamatory. The court held that the test of capacity of a published matter to defame is, in this case, whether any of the search results complained of are capable of conveying any of the defamatory imputations alleged. In finding Google liable, the court held that there was no evidence that would have been apparent to an ordinary, reasonable person using the Google search engine that Google made no contribution to the elements or combination of elements to those search results that convey a connection to Mr. Trakjija and criminality. The defamatory matter can disparage the plaintiff by imputing, for instance, that they are dishonest, disloyal, or a criminal, but the imputations must attract a level of blame or responsibility on the plaintiff's part. It is not defamatory to make comments relating to aspects of a plaintiff that he or she has no control over, such as ethnicity or physical appearance. As the Boyd case demonstrates, the statement that a plaintiff was overweight did not attach any blameworthiness on his part. However, such a statement may be defamatory where it portrays the plaintiff in a ridiculous light. Yes, I did see that, though. So that's essentially defamation law. So the plaintiff has to show that it has caused hurt and what is defamatory, and the defendant has to plead the defense. So you've got the justification defense, again in Australia. You've got contextual truth. You've got absolute privilege, publication of public documents, fair reporting of proceedings, qualified privilege, honest opinion, innocent dissemination, triviality, truth, absolute truth, qualified privilege, fair comment. Yeah. So there are 9 statutory defences. So there you go. Hopefully that sort of helps you with particularly the little bit of defamation. I think, you know, so remember that the elements of defamation is the matter contained defamatory imputation, the matter identifies the plaintiff, and the matter was published or communicated to a third party. They're the 3 elements of defamation that we need to look at. So it comes down to what would a reasonable person assume by reading what is said. And in my opinion, that's where Katie Joy fails, because she's making these implications that, these innuendos about the Chrisleys. But that's just my opinion. Okay. So anyway, this is only going to be a short one because I need to go and get ready. I've got to pack for the hospital tomorrow. For those of you that joined me late, I did find my purse. It had been left at the supermarket, believe it or not. Because I even went to the supermarket. I said, I know this is a really big long shop here. And she goes, oh, I've got your purse. Because I wish I had better access. Yeah, look, we don't have what they have in America. I can see some benefit to that, Cal, having that little bit of privacy. But you can, the only court you can really get access to at the moment, I think, well, the one that I spend a lot of time on, burden of proof falls on the plaintiff in the US. Malice must be proven as well. Okay. Yeah. Cool. So anyway, I'm just waiting for the judgment for the Barilaro Google judgment to come through, but that hasn't. Justice Reyes has just started another hearing, so I don't suppose another trial. So I don't suppose that he'll be giving his judgment anytime soon. That was April, wasn't it? The end of March, 1st of April. So we're still waiting. As soon as there is a judgment, I'll let you know. But yeah. Anyway, I just wanted to let you all know that that's all happening. But so the Federal Court of Australia sometimes has links, so you can watch the Ben Robert Smith case. That one has been put onto a YouTube channel. But yeah, we don't have access to a lot of the hearings and stuff, which is a bit unfortunate. Oh, I'm sorry, Bo, that it's that's done that. Ooh. Like there are some. I've got a case that I found, another defamation case, which is really interesting. Which we might break down. So remember, in Australia, we can only get really judgments. Now, this is a defamation case that involves Google reviews, believe it or not. Joint hurt feelings, vindication, permanent injunction prohibiting respondents from further publication of defamatory content, assistance of damages. So this one is interesting, and this is Justice Jaggett. And so this is what the orders are. But if you actually look at the facts, it involves a doctor and some Google reviews and people putting up false reviews. So this has just come down. This has just come down on the 21st of April, and it's a 400. It's a so this is damages for non-economic loss, aggravated damages of $420,000, special damages at $31,500. They're restrained from permanently publishing or republishing false reviews. And pay pre-judgment interest, so they're going to pay interest on the judgment. And anyway, so I want to have a look in, because we don't get access to all the documents. They're very detailed judgments, so they actually give you the background of the case, so we'll be able to work it out. Like there's a link there as well. So it's to do with the Ray MD's website. So it's a very interesting one. Again, hi, totally clueless. Yeah, we were just looking at all the latest stuff hitting the fan with KJ. So, and Chrisley. Oh, we were talking about the latest KJ and Chrisley's because Katie Joy posted that she's discontinuing her motion to dismiss, and she's instead kept filing a counterclaim against Todd Chrisley. And Todd Chrisley sort of said, "Bring it on." Yes, Eileen. Yep. We looked at that. We've seen that. Yes. Lindsay is not playing ball at the moment either. So I'll just pull that up again for you all to see. I think, as I said, I would not be surprised whether she's not going to issue a cease and desist to Katie in the first instance, and then we'll see what happens. Let's not let me do it. But as I said, that's just, again, my opinion. That would be my advice. My advice. So this is what was said. I'm just going to remove this so we can make it big for you, so you can all read it. I can't make it any bigger, I don't think. So she says, "Stop reporting attaching my name and image. My attorney will be in touch this week. Stop reporting on any Chrisley." So is what Lindsay has said. Stop reporting on any Chrisley. So look, I'm surprised she hasn't. I think Lindsay's sort of trying to say she doesn't really want to have to sue her, but it may be getting to the point where she's going to have no choice, because if she's going to keep talking about her. So in my opinion, she's trying to stall. It's all to do with the discovery, in my opinion. She has, the Chrisleys have already filed a motion to compel, and I don't know when that's been, when that is being heard. So by now saying she's got a counterclaim, Lindsay needs to be really short on her communication with KJ, because she will. Oh, we know that she will release it all. So I'm thinking, it's to try and stall. She's hoping that that's going to push back the I'm thinking she's trying to push back the discovery information. That is what I'm thinking. But again, I could be wrong. But it's a stalling tactic. Why else would you do something a day before something's supposed to be heard, other than to really mess around the court? KJ's trying to, in case he goes to prison, but she doesn't realise that that case can go on without him. So that's the thing. It's not going to go away, and he said that. And as I said, if she's hoping to get information from his criminal case to help her civil case, then she shouldn't be covering the criminal case, because she could then be deemed. There could be a bias or something come through that. But she's just, I think she's just trying to delay everything. Well, I've got to get going to short order cook. I've got a couple of assignments to finish too. So, and I'm always talking about assignments, always. Anyway, so thank you for joining me. I hope it goes quiet for the next few days, because I'll be offline. I have my surgery tomorrow, so I don't know when I'll be back, but hopefully I'll be back soon. And until then, I'll catch you all later. So bye for now.